Hi, Bill Henshaw here again with the video you're going to love. Has any of you ever wondered what a trial by jury is supposed to be like and what would be recognized by the original intent of the framers of the Constitution? The definitive book on the subject is called Essays on Trial by Jury by Lysander Spooner, written about 1850. And I'm going to read you an excerpt literally right from the beginning, page 1. And see if you recognize any of this in those traffic court trials you go through, or even criminal court quote-unquote trials. You're not going to, it won't even bear any resemblance to this. Page 1, listen to this. For more than 600 years, that is, since Magna Carta in 1215, that's over 800 years now, isn't it? There has been no clearer principle of English or American constitutional law than that in criminal cases it's not only the right and duty of juries to judge what are the facts, what is the law, and what is the moral intent of the accused, but it is also their right and their primary and paramount duty to judge of the justice of the law, and to hold all laws invalid that are, in their opinion, unjust or oppressive, and all persons guiltless in violating or resisting the execution of such laws. Unless such be the right and duty of jurors, it is plain that instead of the juries being a palladium of liberty, a barrier against tyranny and oppression of the government, they are really mere tools in its hands for carrying into execution any injustice and oppression it may desire to have executed. But for their right to judge the law and the justice of the law, juries would be of no protection to an accused person, even as to matter of facts. For if the government can dictate to a jury any law whatever in a criminal case, it can certainly dictate to them the laws of evidence. That is, it can dictate what evidence is admissible and what inadmissible, and also what force or weight is to be given to the evidence admitted. And if the government can thus dictate to a jury the laws of evidence, it can not only make it necessary for them to convict on a partial exhibition of the evidence rightfully pertaining to the case, but it can even require them to convict on any evidence whatsoever it pleases to offer them. That's what's going on now. If you don't recognize this in the traffic courts and our criminal courts, this is exactly what's going on. And this is a definitive version of what the trial by jury should be. And I can tell you from recent experience from my friends in Colorado, it's the first time I've done this. And, I sent them my jury instruction packet, which is currently 572 instructions. I've never had a case to use it in any of my situations. Even my South Carolina felony case, where my valued and trusted assistant sent them a digital copy of this, and I would love to have been a fly on the wall when they got this one, but never used them. But I sent this to my friends in Colorado. The black robe bastard in that case denied 572 jury instructions at the stroke of a pen. Bang. No objection from the the DA, who should have been the one making the objections. And this, if you don't realize it, the dumbass is what, an executive officer, right? If the trial judge, quote unquote, is doing that, he's, in theory at least, a neutral judicial officer. Where is the doctrine of separation of powers that we're supposed to have there? Not only that, it got worse in this case because the bastard then instructed the jury with jury instructions that my friends never saw or had a chance to object to. And what, in effect, he did was to get them to bring back a directed verdict of guilt, which Spooner didn't overtly say in the excerpt I read, but that's what's going on. If they can do that in directed verdict of guilt, why bother to have a trial? That's how bad this is and how basic it is. And if this case gets to the 9-0 farts in my former hometown of Washington, D.C., and I hope it does, even Ruth Bader Ginsburg is going to get this one. This is how bad this is. If you can't put on any defense, why bother to have the trial? I'll be damned if I can figure it out. Any of you that can figure that out, let me know. And by the way, those of you listening here, that if you want a digital copy of this book, I'll be glad to send you one. if you send me a request for information for my constitutional defense document package, this will be bonus material that you'll receive. Send me an email at youwinincourt@gmail.com and read this. It's astounding, all of it. It's like nothing that we've seen here for probably close to 150 years. But it's the way it is. It's the trial we're supposed to have. And if the juries aren't the palladium of liberty and can restrain government, and as I said in other videos, there's no place that our interests are represented in government. All we have now are political action committees that pay off all these badgers to run for Congress or whatever and do their agenda. Our interests aren't represented. And if they were, think about this a minute. We have 300 million people approximately in the United States, and with the census coming up next year, another subject I'll be talking about. But if you do the math, we have 435 people in the House of Representatives. The Constitution says, Article 1, Section 2, Clause 3, I love it, 1, 2, 3, the fourth graders will get this one, that the maximum amount of representatives per inhabitants is 30,000 to 1. At the present time, doing some simple math, we should have close to 11,000 members in the House of Representatives. What do we have? 438. Geez, that's not even 5% for crying out loud. And they think they have a quorum to do business here? I don't think so. But that's the problem, even if. And even if, I mean, how do you get the attention of your representative in Congress, for example, when she has 800,000 constituents, and we have the right to instruct our representatives, by the way. That's inherent in the whole system. How do you do that with that many people? I mean, how can they possibly be responsive to that? So there's a lot of questions that go with it here. But you get to read this book that you can get complimentary from me on the Essay on Trial by Jury. You'll see a lot of the problems we have today, and they were just started to be formulated at the time this book was written in the mid-19th century. But it's well worth reading. I got a great digital copy. It's highlighted. I've got some annotations in there. You read this, you will learn a lot. Remember to like this video, tell your friends, subscribe, and thank you for listening.